So I think with that, I'm going to go ahead and open up this third day of our fifth ICWA Institute, and just know that each of you here today are here because you want to learn, because you want to grow, because you want to do the best interest for Indian children and families. So I appreciate that immensely. So I'm very excited to introduce our speaker today, who has sat in an ICWA court in Spokane County for many years, comes to the table with great experience, wisdom, and I'm just honored for all of you to hear the bench perspective from Commissioner Ressa. Thank you. Let's all welcome Commissioner. Thank you.
So I'm aware of the limitations of Zoom engagement, but I do hope that those of you who think of something you want to talk about with respect to Indian child welfare in courts, or a question about what I'm going to say, or maybe I said something different than what you've heard from Commissioner Mack from Clallam County, that we can really delve into why we might see things differently. Let me introduce me to you. I'm one of the commissioners in Spokane County Superior Court. We have 8 here in Spokane. We have 12 judges. And different from a lot of the other counties in Washington state, our court commissioners handle the dependency dockets. And that is because of the team structure that we have here. So we have 7 teams of dependency caseloads. My team and caseload only includes Native American children. And I stay on the case from beginning to end of dependency. And other communities, courts where the judges manage the reviews and the fact findings rotate either every year, every couple of years. That's just not how we've decided to handle them in Spokane County. One of them's not right or wrong, just that every court, based on their own ability to manage their caseload, whatever that is. We have about 1,100 dependent children in Spokane County. That's how we do it. I have been the judicial officer for this team for, it'll be 15 years in May. And before I was a judicial officer, which I've been for 16 years, I used to be a commissioner in Grant County. I was an assistant attorney general. And the only cases I managed as a trial attorney were the cases involving child welfare. But it ran the gamut from dependency to termination of parental rights to licensing to eventually I defended, at that time, DSHS in tort suits that were filed against it. So in the 25 years that I've been a lawyer or judicial officer, this has been the area of law that I find the most interest in, the most complexity in, and the most reward in. When you get to watch a family transform and permanently alter the course of their child's trajectory in life and be a part of it and be an important part of it, you're not doing all the work, but you sure are reaping the reward of being a part of that transformation. And it has taught me so much about compassion, trauma, healing, and how we all want to believe, especially in our Western culture, that if you just work hard enough, everything is going to be fine. But some of us start from so far behind the starting line that it becomes impossible to try and, sorry, what's that? Okay, sorry, I'm doing a presentation. Can you just put it? And another issue, so it's not a problem. Thank you, I appreciate it. I'll put a note on my door. But people might still need to come. In any event, that's who I am. I'm also a mother, so I have a parenting experience, which we'll talk about today, how to manage that when it comes up for you when you're giving recommendations. I'm a sister, I'm in a big family, and my family's culture is really important to me. The food we eat, the things we say, the traditions we have. So we'll talk a little bit about that too, and specifically involving ICWA courts. So there are 16 what are called ICWA courts around the United States, meaning that there's a specific, not just docket, but a way of doing court a little bit differently because the Indian Child Welfare Act is involved. I'm the only designated court right now in the state of Washington, but we just had a summit a few weeks ago where there are several other counties that are interested in having ICWA courts established. So if you are in one of those counties, I hope you will join the cause of pushing that having a designated ICWA court increases expertise, it increases compliance, it increases the good outcomes for Native American children. At least around the country, the data is showing us children stay in care not as long, permanency is established, and more kids are placed with family or with their parents because of the way the court focuses on making sure that Indian Child Welfare Act is complied with. So I probably don't have to tell you, I think this is your third day of the Institute, that Native American children are disproportionately represented in the child welfare system. And that's been true for a very, very long time. And it's true now because of government policies that brought Indian children into the child welfare system. So we don't know today how to separate the purposeful separation and annihilation of Indian families done by the United States government to then have generations later, probably only a couple, maybe three, of why we still see a disproportionate number of Native American children in the state court system. When you get to know some Native American families, if you're the advocate in the case, you, at least probably for the next decade, will learn that somebody that they know that is alive has had an experience with the boarding homes in this state and our surrounding states, and what that experience did to their family. And if you can think about, if you don't know this history, if you don't know the news recently about now finding a lot of bodies of Native American children where the parents were just told nothing about what trauma that would have put upon a family to just, again, shift the trajectory of that family into mental health issues, substance abuse issues, violence, failure to just cope with stress when you've lost your children. So I just ask that there's constant tenderness and grace around somebody's likely emotional, potentially angry response that the family's children, so whether it's the parents or other relatives or the tribe itself. Well, I don't expect any of you to be abused verbally or with any kind of harassment. I do ask that you just consider why there might be a very different, potentially, and heightened emotional response to the removal of children. It changes the world for a tribe. So if you can think about, because the Indian Child Welfare Act is based on a political status, the 500 plus sovereign nations that have governments within the borders of the United States are, like I just said, sovereign nations. So just like they were France or Canada or Mexico. And if you went into one of those countries and took all of their children, it would be difficult for that country to thrive. It would need its citizens, so the members, to carry on the traditions, the economy. So to remove constantly the members, the citizens of a nation, reduces the ability of that nation to survive. So that's why this is such a big deal. And in 1978, our Congress recognized through the passage of the Indian Child Welfare Act that there will be recognition differently because of that sovereign status. Tribes will get notice. Tribes will be allowed to participate, even if anyone objects. There will be preferences about where children will be placed. Certain expert testimony is going to be required. And those are things, again, based on the sovereign nation of those governments. So just like there's all sorts of conventions between the United States and other governments when it comes to children or children who might have been stolen from one country to the next, that is how important this law is. And so we'll talk a little bit today just about how it goes in court, but when you find yourself, or when you find yourself talking to one of the other stakeholders in the court that they're frustrated that the ICWA applies. Oh, I got to give notice now. Oh, now there's a higher burden of proof. Oh, now we have to do active efforts. That frustration or irritation or annoyance is really misplaced. It is not the fault of the ICWA that things get harder. It is because there's not either expertise, because there's not an easy way of complying, meaning that the state's lawyers or parents' lawyers don't have processes in place to comply with the law easily. That's where the focus needs to be, on solutions, not in being upset or trying to disprove that the Indian Child Welfare Act applies. Probably throughout this institute, you keep hearing about the gold standard in child welfare and the gold standard in lawyering, the gold standard in social work, and the gold standard in being a judicial officer. And so I'm always wondering why people wouldn't want the gold standard for all children. So if you hear someone saying, I wish it didn't apply here, what you're saying is, I wish these children had less than a gold standard. So it is so important. I know you've heard this throughout the week, to keep asking the question, keep getting the answer about whether the Indian Child Welfare Act applies to the case. And if we don't know, but we have possible reason to know, then we just apply it. And we take the angst or the frustration out of being concerned that people aren't responding or tribes aren't letting us know if this child is a member or not. I think you probably have heard that the state of Washington, with the change of case law in September of 2020, has inundated the 500 plus federally recognized tribes with legal notices. Just responding to the state of Washington alone is a full-time job for most tribes in their membership office. And yet they have 49 other states to respond to. We're set up in our state system with 39 counties. So we have 39 different counties sending the 500 tribes notices. And then if you look at other states around our country, like the state of Minnesota, which is not that much bigger than us, they have 84 counties that send notice to the 500 tribes. If you think of the volume of legal notice that must come in a law that has not been updated to reflect the possibility of electronic notifications, emails, et cetera, the law requires a specific way of doing registered mail, which probably none of us use anymore, but that is still what the law says. So it has to be complied with in order for findings to be made that notice was proper. So again, it might be a frustrating piece, but it's not the ICWA's fault. It's the other systems that need to either adjust, or we need to start talking about how do we update a statute, with some fear that if you open it up, you might be opening it up to other changes that aren't what are going to be helpful for kids. So I don't know what the desire is, but I do know that if you are concerned or confused about, I should say, why notice takes so long, is because it's required to be by registered mail. So I'll pause for a minute, as if any of you are in Eastern Washington and you know we've had a lot of wind and rain the last day and a half. The leaves are being picked up outside my office with a very cool machine, but it's very loud. So if you can't hear, just wave at me and I'll speak up. Every time I do a view from the bench conversation at a conference for people who volunteer their time or advocate for kids, even if they're paid, I know they don't get paid the number of hours they actually work. I want to start with gratitude. I want to tell you that I for sure know that our systems need very dedicated and trained people to advocate for the best interests of children. It is the only role in the court that gets to focus on just best interests of children. So even if the child has an attorney, they have to advocate for a stated interest. Many of you use your own time, your own resources, and certainly your emotional energy in advocating for the best interests of children. And that is an admirable endeavor for a human to undertake. And why I make sure I talk about this on purpose is because I can't always do it in the court hearing. So if you've had cases, you probably know that lots of parents have an enormous mistrust of systems, of courts, lawyers, judicial officers, social workers. And so if at a court hearing, that person who's still very much in the throes of mistrust and distrust, and if you're a Native person, you probably have a lot of valid reasons for that mistrust and distrust. If I show gratitude toward a CASA or an advocate, the trust in the court system is going to end and likely not be able to come back on. So even if I want to say that was a very helpful report, or even I want to say I really appreciate the efforts you've made, there are sometimes I will not do that. Sometimes I will, because by the time a case turns around and a parent is engaged and they see that people are working toward getting them back with their children, they start showing the gratitude and they start thanking people in the courtroom. And then I can always add to that, but keep your perspective of what's happening in the courtroom very generous if you can, to understand that I may, or your judicial officer may on purpose not say something that sounds complimentary or that would sound to somebody who's listening through the ear of mistrust and distrust as if you're on their side or as if somehow you're aligned with them. So that's why. So I'm saying it now. Please remember this part if you're ever feeling like it's just not worth it, or you don't feel like what you're doing is valuable, that is not, well, it's not accurate. What you're doing is very valuable. So as a judicial officer, I don't get to look just at the best interest of children. In fact, some statutes tell me you don't get to it all until I make some other findings. So that is why you might see sometimes the court really looking toward the child's advocate to hear about what's in the child's best interest. Remember that you can recommend things that the department can't. And if there's no parents involved or engaged, parents won't. So things like relative placements, and specifically in Native American cases, we have not only the legal obligation to place with relatives, but we have relatives that have been potentially scattered around the nation. We have relatives who have criminal histories from times in our criminal justice system where our racial inequities that we're exploring today were even more prevalent. And the department cannot, not the individual social worker, not his or her supervisor, not the area administrator, they cannot by policy argue for certain relative placements if there are certain CPS findings and if there's certain criminal histories. So you might be the only one that can. And relatives, in my experience, often don't understand why they're not being proposed to the court. And I encourage CASAs to keep, and advocates to keep asking, are there relatives? Are there relatives? Are there relatives? Because the Indian Child Welfare Act requires placement with a relative. So does the state statute, by the way. So for all children, we should have an enormous percentage of our kids out of foster care in relative homes, and foster care homes saved only for those kids who truly do not have an available relative. And the available and appropriate relative conversation is what we should be having in court. You're probably the only person that can ask for visits with non-parents. So there is a grandma or an uncle that the child has a significant relationship with, but the parent doesn't want that, and the department can't support it for whatever reason. So you're in the best position to ask the court to keep that child connected to his or her people, and to constantly ask the question to that child, who are your people? Who do you need to see now that your life has been so disrupted in this child welfare system? We just had a new law change. So before July, you're probably the only person that was going to ask for the location of visits to be in a more relaxed setting. The department has contracts. It doesn't have the flexibility of options that you might think of, where you can suggest a friend or a neighbor or a church, a place where contact between children and their parents can happen in a safe way. And I know you've gone through the safety training sometime this week as well, because safety doesn't always mean supervised visits in a facility. That is not the only way you can keep kids safe, even when they have parents that have substance abuse issues or mental health issues. In my experience, both as a lawyer and as a judicial officer, I see the tension and struggle and discomfort around when the advocate has a different opinion from the social worker. And just again, encourage you to understand that reasonable minds can differ specifically about best interests and specifically about what safety looks like. So neither one of you need to necessarily be wrong when there's a difference of opinion. However, what I've noticed, because so many advocates don't have that agency behind them as a support or a lawyer sitting next to them as a support, they will go quiet and agree with the social worker. And that's just, I think, not good for kids. We need to have hard conversations. We need to have uncomfortable conversations. We need to get comfortable with the uncomfortable to really flush out what is best for a child and how to heal from the fracture and disruption that's happened to them. So maintain your position regardless of the contrast, as long as, and we'll talk about bias in a minute, as long as that position is based on your investigation of what is in the best interest of the child. I cannot think of a definition of best interests that doesn't include a child's right to resolve the relationship with their parents. So we do certainly have those horrifying, heartbreaking cases of physical assault, sexual abuse, where the relationship is not likely to be long-term or even permanent, but the resolution is important. So to explain that a little bit more, does a child need counseling to say goodbye if a parent is relinquishing their rights, for example? Do we need to have that conversation for them or make sure we're advocating that it happens? If there's a criminal conviction based on a crime against that child, what is the way for that child to resolve the resolution of that relationship? You have to advocate for that right, unless and until the right to an alternative permanent plan prevails in your best interest analysis, meaning that there's just no possible way there can be resolution of a child with their parents. And it is difficult after months or years sometimes when you've watched a child thrive in someone else's home to think about the possibility of changing that environment as being in the child's best interest. But there's lots of research that I encourage you to check out about when you fracture the relationship between the child and the parent, what long-term effects that has on kids. It's really different in the way that the fracture between the parent and the child. And while that's still painful and it's still potentially devastating for people, it doesn't have the same time of long-term psychological, relational, traumatic issues that it does for kids when that separation happens between them and the parent. I'm going to switch up what I was going to do. I'm going to show you a slide that I want to share with you about courts in general, tribal courts and state courts, because I think it will inform some of our other conversations about bias and reporting and why we sometimes disagree. And so I'm going to share just briefly. I'm not going to make us all be in a tiny square in the corner for too long. So we can come back to this in just a moment. I'm going to just share this with you from Minnesota. It's actually adopted from a training between a state court judge and a tribal court judge. So differences in approach. So the left side of the screen of the American justice systems and in general tribal justice systems. So tribes, not all of them have a court. So not all tribes have a tribal court. The ones that do are different, and tribes get, because they're sovereign nations, make their own laws, have their own rules. But as a general approach, these are some values and difference in approach between state courts and tribal courts. So American systems of justice are that top-down power dynamic. When you walk into the room in most courtrooms, the judicial officer is sitting higher than everyone else. There's your honor words that are used. People stand up when you come into the room. It's a top-down power dynamic. It is expected that that power dynamic be honored and respected as far as how you speak to people, who gets to speak. Whereas in tribal justice systems, holistic participation and importance are more even, more equal. And it's a holistic conversation instead of a top-down conversation. In American justice systems, if you've been in our courtrooms, communication is rehearsed and argumentative. In fact, it's called argument. It's on purpose to have two sides or three sides argue a case, where in tribal systems, and I really encourage you, especially if you're located close to one, to go watch. I find myself often very jealous of the way a tribal court judicial officer gets to manage their courtroom and use words from the heart and enter the heart, and communication being fluid and essential. Well, you've seen the Lady Justice symbols in our culture. She's blind. She doesn't have feelings, and she's supposed to be neutral, but I would say sometimes even robotic. And how a human being can be in a child welfare docket on any given day and not feel is impossible to me. Because I'm telling you that if you walk into these cases and don't feel, then you're probably in the wrong spot and need to go do some work on bringing your own armor and taking it off. Because these are very hard circumstances. They're very emotional, tragic. People are absolutely potentially where they should be given the trauma they've experienced. So tribal court systems get to acknowledge that a little bit much better than state court system. So the attorneys are the ones speaking. The non-resident, non-party voices are the primary voices in the room, where if you were in a tribal court system, the parents or the relatives or even the children would be the primary voices in the room. We have winners and losers in our system. And as you can imagine, in dependency court, there aren't winners and losers. It is tragic all the way around, and it can be triumphant as well. But each particular decision, someone's always losing. The tribal approaches are oriented toward resolutions and healing of broken relationships. And I think we're getting better at that in some of our therapeutic courts. We have drug courts, we have baby courts, we have courts that are being set up in a therapeutic way to focus on healing of broken relationships. But we're not quite there in the designation of dependency courts as therapeutic models. There's different funding streams, there's potentially different rules or staff that would be needed, and we haven't made it there yet. Our juvenile justice system is starting to do a lot more with restorative justice, peacemaking, and healing as part of its system. We just, in most of our courts in the state of Washington, have not incorporated those concepts yet. You know, in the American justice system, in our constitutions, all of our state constitutions, the United States Constitution, there's a separation of church and state, a separation of religion and spirituality, where in tribal courts, you'll see ceremonies, prayer, spiritual practices come into play in the courtrooms as well. The strict time constraints in our courts often lead to more docket management than they lead to how much time do we actually need for this case. So most of our dockets have more cases than we can manage. That's a resource development problem over our entire state, but we are so focused on being able to manage cases in 15 minutes that sometimes we forget that that is not enough time given the issues that we're resolving. Our system focuses a lot on compliance and contempts and sanctions, that punitive removal of people from either society or from each other, where tribal systems will focus more on corrective, accountability, responsibility for change, responsibility for reintegration into the community. It's just a really different focus. If you've seen a recent video on the criminal justice system in America is based on what was created in the 1700s of putting people in dungeons, if anybody has seen that. And we're still using that type of punitive system, even though we know for now decades that it doesn't work. It doesn't do what we wanted it to do, hold people accountable and keep our communities safe. Whereas tribal court systems focus a lot on that community and really work on resolution. How do you hold people accountable? How do we keep communities safe at the same time? And just putting people in cages, we know doesn't work. And tribal systems are just more flexible in being able to determine how better to manage the issues that happen in their communities. One specific example we have in the state of Washington is when someone is arrested for a domestic violence offense. Under our laws in the state of Washington, the police have to arrest someone. Not tribal systems aren't required to have that law. I also see so many times that then there's a no contact order put in place between parents and kids. And it's in a totally different system than the dependency court. And I lose all ability to order contact or order counseling started. And so we have a physical assault that happened in a fit of rage with substance use and a mental health break. But now the parent is getting treatment and is working on things, and it's time for family therapy. Yet I don't have an ability to do that if there's a criminal justice system that has put a no contact order in place. If it's in with my own county, often I can get someone in the system to help me out. But if it's not within my county, that becomes quite an issue. In a tribal system, that's not how it would work. So that with that framework, I want to just talk about some of the things that I want you to be thinking about when you're presenting in a court on behalf of a Native child. And really, some of these things, especially when I talk about bias, apply to any child. But just remember how powerful you are in the room, specifically in the eyes of the parents, that you're a person that they believe knows the system. You're a person that understands things. Sometimes they believe you have relationships with the social worker, because you might show that out in the hall if we ever get back to hallways again, or that you know the judicial officer and he or she knows you. So parents come into the room not believing they're at an equal platform with the people that are there doing their work or their job. So to remember that and try to speak to it as much as you can. You have to check your own biases, and you have to know that they exist. You're not wrong, you're not bad, you're human. And if you believe you don't have biases, then you're not human, because you do. It's where your brain works. It's the way it develops. It decides how to keep you alive. That's why it's there. It believes that if there's a threat, it has to do something. If has to fight, it has to flee, it has to freeze. And you have to be aware enough to know when that part of your brain is engaged and when it's not. Things like poverty, discipline style, nutrition. These are just things that I have heard over the years. Race, video games, choices in family structure, sexual orientation, addiction, mental health. First of all, it's likely that given the prevalence of some of these things in our society, that you know someone, have a family member, or have an experience with one of these issues. That automatically creates a bias for you because you have an experience. That bias can potentially help you have more compassion or have more grace, or it could potentially help make you judge something in a way that isn't about the case, but is about your experience. So it's very important to, if you haven't before, take some of those tests about bias, know where they come from in your life, and know what it feels like in your brain when they're showing up. I hate violent video games. Hate them, hate them, hate them, hate them, hate them, hate them. I hate my kids playing them. I have argued, I have 2 teenage boys I can't even stand to listen to the gunshots and the words that my kids are saying to each other. I just killed you. I hate them. However, it is not a child dependency issue if parents allow their children to play violent video games. We certainly have a societal acceptance of this. We have, I think, a world that's gone amok and created its own energy and power around our kids playing video games that we're not intervening on for a variety of reasons. But the research shows us that absent some other risk factor, which would probably apply to most of our kids in dependency, that violent video games in and of themselves do not make people violent. But when kids have other risk factors, they're exposed to violence in their home, for example, they are abused, they have exposure to domestic violence, that those kinds of games can be harmful to them. So just to, as an example, when it comes up in my court, when I hear someone say, and she lets them play Fortnite, that I know I have a bias about that. And I have to check in on that, and I have to ask a lot of questions so that I know that my bias will not be a reason for a decision that I make or a judgment I make in the case. Discipline style, poverty, nutrition are other examples that come up a lot. We have to really watch that we are not pulling kids away from families because they're poor. There has to be a connection to neglect in a way that's purposeful or that is the result of substance use or mental health, because I don't think those things are purposeful. But poverty in and of itself is not a reason to pull children from their parents. Choices in family structure, we have a culture that has decided that it is valuable to each of us to live individually in our own space. You look around the world, that is not how everybody does it, and children do fine in those cultures too, where people live communally, where generations live together, where there's a lot of parenting done by aunts and uncles and grandparents. And so while it's different, for sure, make sure that that difference actually negatively affects the child before you are believing that for some reason the child shouldn't be in a situation that just looks different. And tribal communities have to rely on each other in a variety of ways, especially if they're self-sustaining. And so they do use the extended family members to help with child rearing. And it might not look exactly like a family in a dwelling. Always, 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 this is not personal to you, ever. Even if a parent says it is, or even if the lawyer tries to argue that it's personal, it is not personal. This is not your child. This is not your family. You're doing an incredibly important job, and you have a valuable role to play. But when someone disagrees with your perspective, you can't take that personally, because it's not about you. It's about that perspective that you shared. Because you can have strong feelings. So I just encourage you to, when those come up, to make sure that you're staying professional and that the feelings are not because you personally are affronted or upset, because that will cloud your ability to make a neutral judgment, or at least a judgment about the circumstances before you that are not based on something personal. And when the court doesn't agree with you, it's not because it doesn't respect your opinion, or that it thinks you didn't do a good job. It just might have to be thinking about something else, like what the case law says about parental unfitness. So don't bring your bias to the case. Well, that's not the right way to say it. You will bring your bias to the case. Don't bring your bias to your report, either in writing or in your oral report. Before I move on to reports, I think we might have some questions in the chat, and I'm not good at keeping up. So if you have a question, I think someone just did. Can you say something about homelessness that relates to safety and best interests? It's probably not a dependency issue per se, but wondering how commissioners deal with this problem. Yes, it's probably you, especially in our state right now. Our homeless population grows and is growing by the moment, I should say, because of the eviction moratorium that was just lifted. And how can someone keep their child safe when they're homeless? So homelessness in and of itself, just being homeless, is not a risk factor for safety. You have to add homelessness and sleeping under the bridge, homelessness and the parent leaving the child in places where the parent doesn't know who's caring for the child, to add what the nexus to safety is. So if you can think more about the details of the homelessness versus the fact of being homeless, you will have a better way to articulate why you think the child might be safe or why you think the child might be unsafe. a little known fact, it's probably frustrating for those of you in funding stream jobs, but you have to be homeless in order to get housing. And so when you are couch surfing, if that's the appropriate term, or you are staying with a friend, lots of systems will not find you to be homeless so that you can be eligible for housing assistance. So we don't want to judge homelessness in this way by saying it as if it's the bad thing, because some people actually have to be homeless before they can be entitled to assistance for housing. They also have to keep their child safe. And so one of the roles of the advocate, of course, is to think about what ways can that happen. Can they stay with a relative? Can the child temporarily be somewhere so the parent can get their 2 weeks of homelessness in and then be able to have their child back in a setting that will be safe? So I don't know if that answers your question, Nancy, totally, but that's my encouragement, is homelessness in and of itself isn't the safety factor or risk factor. It's what's going on around that homelessness to consider.
Commissioner, would you like me to monitor those? I forgot to ask you. I can monitor those, and if you don't mind, I can interrupt if I think it's at that time.
That's
Will
great.
that be fine?
That would be great. Thanks.
Okay. You're
And
welcome.
I see that Ryan also put the implicit bias test from Harvard. Those are really fun to do, actually. If you want to find out if you're biased against redheaded people or people with dogs, and you might learn some things about yourself that you didn't know, so that you can just be curious about it and check in on. Remember, bias is a part of being human. It keeps you alive. It is not negative. It is not wrong. It is part of who you are. It's just a matter of knowing that you have a bias that's being impacted or that's being influenced by the fact pattern that's coming before you. The courts, as we just talked about, the difference between state courts and tribal courts, that a lot of the tribal codes that I have read do not have the kind of structure and specificity around reports and writings that state courts have. They certainly don't have a lot of the rules of evidence that state courts have. And our courts are courts of record, meaning that when I make a decision at a trial or a review hearing, the record, what's recorded on the machines, as well as what's in the court file, are the only things that I can base my decision on. So if it's not in the record, it didn't happen. It has to be there. And so that's why, by statute, the social worker has to write reports for review hearings, and they're due at a certain interval depending on the type of hearing. Most counties, and someone correct me if I'm wrong, if your county doesn't make you, requires a report from the child advocate as well. And those reports are incredibly valuable to me. I work with hundreds of other judicial officers who would say the same thing. So again, if we don't mention the thoroughness or the value of the report to us in a decision, it is not because it's not there, but because maybe, we could have forgot to tell you, or we've on purpose decided that this is the kind of case where the parents aren't yet trusting the system. So we're going to save our compliments for something like this. They have to be timely. There's just so much frustration when we've reserved the time that we've reserved on a docket and something's not timely, and so that it has to be moved, and we don't have time a week or 2 weeks later, because those are all full too. So they have to be timely, because everybody should have the ability to respond and think about and absorb what's being said. Some of these are really hard to read, if you can imagine, if you're the parent, and what you as the child advocate might be saying about their child, especially how well their child might be doing now that the child's out of their care. That would be very difficult to read. Or because this is what many of you describe in the reports I read, how funny the child is and what he or she is doing and what milestones they're reaching. And for me, they're lovely and the pictures on the front, but then think about the parent missing those things, not being a part of those things, not seeing the kinds of things that even you're getting to experience with their child. So to have them timely gives the parent an opportunity typically to work with their lawyer about some of those feelings that they might be having that they want to react instead of think about and be able to respond appropriately to. So when things aren't timely, we're all in reaction mode. Not a good place to be making decisions, and certainly not a good place to be having effective conversations about how to resolve a case. They need to be factual versus opinionated. So watch for conclusions. She was really aggressive is a conclusion. She yelled at me and she said, and whatever she said is very, very different than just making conclusions about someone's aggressiveness. Because aggressive is a word that we could all have a really different interpretation for, or definition of. There's jokes in our culture about what's the definition between aggressive and assertive at the workplace. And the joke is your gender. So there are lots of different ways to define words that are opinions. So if you keep your reports factual, then people can argue what the facts are instead of argue with your opinion. You get to have, though, an opinion about the best interests of the child. And so that can be based on these facts and based on the circumstances of this case. This is my opinion about best interests. It's important to me to know how you feel about the permanent plan. Often this is missed or overlooked, and sometimes because it's not clear always, I don't think, to the advocate, the kind of hearing that it is. Is it just a regular review, the first review, a permanency planning hearing? So if you always put it in, then you've covered it. And I don't know if it's part of the template or not, but sometimes there isn't a specific description of the advocate's position around permanency for the child. Because when you say this child should return home, when the department has decided the child should have a different permanent plan, you become a powerful piece of an important conversation to have. Because why do we see this differently? And that's the conversation that I would want to have as the decision maker in deciding the permanent plan, of why the person that's advocating for the child's best interest sees this one way and why the department or the parents potentially see it another way. And then the why, of course. Why is that your recommendation? It's been 12 months, or I recommend it's been 12 months, but this parent has been working so hard in the last 90 days to overcome issues that were created over a couple of decades. And I really see hope. And this child deserves to be able to see if that parent can become safe and have a reunification. So those are the whys around. Or this is a parent whose mental health is so severe and there's no insight, and this pattern of institutionalizations, or whatever you have to say about it, has become so chronic that the CASA can't see the hope for reunification and tell me why. I need detail, but not length. There's a hard balance to strike here, because when you're trying to put detail in, and what I've just described to you, trying to put facts in, that it can become pages and pages and pages. But I also want to remind you how long the department's report is as well. And to get to the detail, it doesn't need to be incredibly long. I also find your oral presentation really important. And I know this is very, very different around the courts in our state. So it might be a conversation to have in a stakeholder meeting about, if you aren't getting to speak in court, or if you feel like you're limited in your ability to speak in court, why that is, and if there's a different structure. But I'm not saying you can come to court and in your oral presentation drop bombshells that weren't in your written presentation. That's just too hard on everyone, again, to have to react to new information, with, of course, the understanding that these are people's lives. And if your report was due 14 days ago, you, I'm sure, have all experienced how different a case can look 14 days after a report. So that's report writing. Well, there's a question in the chat about termination and active efforts. We will get there. And if we don't, David, go off of mute, remind me, but we'll get there. So to move on to why we might disagree sometimes, and especially with respect to permanent plans. So in the Indian Child Welfare Court, we, at least my team, has the fewest number of termination of parental rights cases. That won't surprise you if you understand that many tribes do not support the termination of parents' rights. Many tribal court systems have the ability for relatives or other tribal members to do customary adoptions or guardianships where parents still have rights but don't have the physical custody of their children. We have those options under our state law as well. They're just not utilized as often as adoption is. Many changes have happened in the last decade with respect to guardianships and people's ability to have financial support under guardianships, because that unfortunately was an incentive to have termination of parental rights and adoptions over a guardianship, even if a relative would have preferred to do a guardianship, because it felt better culturally, it felt better morally, it felt better ethically for that relative, but they couldn't afford it. And there's so much emotional trauma that is tied into specifically with Native people around adoption. And if you think about what's called the scoop era, or like I've described about the boarding homes, of children being taken and adopted into mostly white families to remove culture. It was on purpose to remove Native values, language, traditions from children and assimilate them, as it was called, into the culture. So there is so much trauma behind the idea of adoption that we have to recognize when it might seem to be the best option for the child, but being so generous and graceful around that conversation about why it would be necessary instead of some other structure. And sadly, historically, the financial support of the child was why relatives chose adoption. Now that is changing, so please make sure you're staying updated about the change, about how relatives can be licensed and have financial support, and how some relatives can be licensed for a particular child in order to have financial support. So they're all, but until recently, if you had to meet the standard of a foster care license, which a lot of our relatives can't do, in order to receive payments under a guardianship to support the child. That is changing, so stay updated. I keep watching the data in my county, and I find it sadly interesting that the Indian Child Welfare team has the most guardianships, and why other teams, if the state law is also placed with relatives, why guardianships aren't utilized in the same way. And I'm thinking it's just a lack of education about the financial piece. So ask those good questions. Require those meetings with the relatives. Tell the social workers, I want a shared planning meeting. I want a meeting to talk about permanent planning and talk about financial benefits as well as legal structures. If you have a lawyer in your community that represents your advocacy program, talk to them about why you might support, specifically for Native children, a plan other than adoption. Just because a tribe disagrees with termination adoption doesn't mean, of course, the state court can't order it. So it's not, quote, off the table. It just has to be talked about in a sensitive and culturally appropriate way. And it really has to be in the best interest of the child. We know from our data that children adopted from the child welfare system are so likely to return to their biological family when becoming adults. And many of them explode out of those adoptions before they become adults. We know that. And that doesn't mean the adoptive home was bad. It doesn't mean that somebody did something wrong. It just means that this need for connection is so powerful in people that we know from our data that that's what happens. So why not at least consider it and talk about it before such a drastic determination is made? And remember that your court officer would be required, and hopefully knows, all of the case law that is coming out of the Supreme Court and courts of appeals around whether or not the statutory burdens of termination of parental rights have been met. And because we read all of those cases, we know that if certain standards are not met with active efforts, and the ability of a parent to resolve the issues that led to the out-of-home placement in the foreseeable future, we know these things have to be considered first. The unfitness is the word that a lot of case law uses of the parent. If those things cannot be proven, then best interest cannot even be considered. So under the termination of parental rights statute, best interest can only even be discussed after all these other elements have been met. It is not just a best interest standard. And that's based on the constitutional right to be able to parent your own child. So a very high burden of proof by a state agency that wants to terminate your constitutional right. They have to meet that burden first before we talk about the best interests of a child. So that could be a reason why your recommendation about permanency might be different from a court. I see this pretty often in the context of a parent who has not been involved in a case, potentially 3 years have gone by and we're just getting to a termination trial and the parent has a new child. But the circumstances of their life have changed so much that that parent gets to keep that child in their care. Maybe there's not even a dependency. It's going to be very difficult, even if a best interest standard was used, to prove that that parent is unfit if they're currently parenting a child. It's going to be difficult. It's not impossible, but it will be difficult. And it may be a reason why a court would decide to wait to order a termination petition be filed, or why a court would change course even after that long. We recognize the federal laws around timelines, the state laws around timelines, and the reality of a child's view of time, and balancing with the child's right to have a relationship with a parent and to have timely permanency. We know that if that decision is incorrect, meaning that if that's not the right way to say it, if a court of appeals or the Supreme Court determines that something happened at a trial court level that was incorrect, that can take years. And that in and of itself is a reason to just consider potentially why you would want to think about a parent who's parenting a child, how it could be proven that they couldn't parent another child.
Commissioner, may I just make a comment from Heidi Walker, who is the NAIR person here in the state of Washington, and she was talking about the RGAP purposes, that the tribes have the ability to write letters on behalf of caregivers, recognizing that they are an extended family.
Yeah,
so I thought that was very valuable.
It is valuable. And some tribes also have 4E contracts and can provide the payments themselves. So this is a really important conversation to be having if you have a child who's a tribal member or eligible to be a tribal member, about what permanent plans the tribe offers. So like I just talked about, customary guardianship or customary adoption or a guardianship within a tribal system might be a permanent plan that you would want to recommend that the state hasn't thought of, not because they're trying to exclude the tribal options, but because they don't know about them. You know about social worker turnover. I think it's about 18 months is considered to be a senior social worker in many of the offices around the state of Washington. So if you've been a CASA or an advocate for a while, you likely sometimes will know more about some of these things than a newer social worker to the case. So ask the questions. There's a tribe involved. What permanent plans does your tribe authorize? And of course, you have to get the state court's permission to be able to finalize in the tribal court. But certainly if there's an agreement, there's not likely to be a problem with that. It's just one more option for the child. Okay, so under the case law, the standard of parenting is hard to define. I think you might have had this conversation likely in the safety framework conversation of how do you describe what is a good parent or what is an unsafe parent? And I don't know the answer to that either. So constantly talking about safety, why you're making a decision, why a social worker is making a decision, why a parent is making a decision about safety. Instead of those conclusions of risk or the word concern, let's talk about safety. And is there a safety issue that all of us can see or that all of us can talk about before we remove kids? And when we're talking about returning kids, why are we not doing that? Because there has to be a safety issue. Let's talk about some of the very specific things that you as the advocate will want to talk about in your report if the child is a Native American child. So the state is required to provide active efforts to prevent the breakup of the family. And that's the language of the statute. So it just flows that it's also required to get the family back together if for some reason there has been a fracture or removal, breakup of the family. And it doesn't stop just because the child goes home, because you haven't necessarily prevented the breakup of the family yet. You're still in the case where there's court orders, there's structure around, there's probably conditions of the in-home placement. There's great resources all over our state and around the country on active efforts. It is not the same as reasonable efforts, and it is a higher standard than reasonable efforts. So when you're thinking about what's reasonable and what's active, active is more than reasonable. So it's very reasonable to send a parent a letter in the mail if you think you have a good address, and give them some phone numbers and names of people to connect with. But if you think about that, there's lots of assumptions happening there. If you send a letter, that's an address that they can get mail at, that they can read English, that they have a phone to make these contacts, that they have transportation to get there, and that they don't have some other traumatic mental health, anxiety issue that's going to get in the way of participating in the things that you reasonably sent to them. So active efforts is doing all of those things. You have followed up to know they actually live there and they got the letter. You followed up to know that they have a phone to call. You have followed up to know that this is not a service that their abuser goes to as well. You followed up to know that they know how to use the bus if there's a bus route. You have followed up to know if there are transportation issues. You have followed up to actively know whether the person who you're trying to get information to and engage in the process can actually participate. You take them to the appointment. This is a social worker's active efforts. And I know that you are all not allowed, I don't believe, to drive people places. So a social worker can get them there, whether it's themselves or however they manage the transportation, but it's actively engaging a person in services and preventing, hopefully, the breakup of the family. It's not making assumptions. So like I just said, when you send a letter, you make a lot of assumptions. When you leave a voicemail, you make a lot of assumptions. Person got the voicemail, they heard it all, they understood what you said. If you send a text, you assume that somebody got it. And if they don't respond to you, we as a culture now assume that the person's ignoring us. But if you're like me, at least my email inbox is so unmanageable that there are times they've fallen off the page and they're there. I just can't manage the volume sometimes. So we have to, I think active efforts stops those assumptions, because we're checking in on, I sent you a text, because now I'm calling you, or now I'm driving to your house. I sent you a text, did you get it? Do you have any questions about it? Let's call that provider together and make an appointment. And while I would love this standard of effort for all parents, we're here today to really talk about what active efforts looks like. I don't know if any of you are from the Bellingham area, but the Lummi Nation has a active efforts guide. It's very helpful. They've spent a lot of time on active efforts for a particular set of circumstances, active efforts for substance use cases, active efforts for mental health issues, active efforts for transportation issues. And they have these checklists that, while are not the Washington state law, are very informative and help with asking of questions if you have a question about whether active efforts are being applied. This is one of those tricky, uncomfortable conversations. First of all, as I just mentioned, the turnover of social workers, it's important to know some of the things about their required training, their hours, the way their cases are weighted, how many cases they carry, what they're expected to know and do around technology, what they're expected to know and do around personalities, what they're expected to know and do around courts. This isn't their training, they have masters in social work. So just and it looks like somebody put the Lummi Nation. Oh yeah, thanks Ryan. Lummi Nation Active Efforts Guide is in the chat. That's a great link to have. as a way of asking questions when it's uncomfortable, because you don't think, as you're looking at the case, that the social worker is making active efforts. So asking those questions in a neutral and non-judgmental, non-critical way will at least get the conversation going. I really like to ask some of these open-ended questions if I'm in that kind of a conversation. Like, would you be open to hearing about my opinion about whether this is active efforts? Would you be willing to hear how what you just said landed on me? Would you be willing to think about what I read here in the Lummi Nation? So that, would you be willing, would you be open? That's a way to ask a question that doesn't sound potentially so attacking to somebody. Watch your tone, because I know that sometimes when I'm really frustrated that I could sound more sarcastic than honest. But it is a way to start kind of those harder best he or she can, and still isn't able to meet the standard of active efforts that you think, or maybe even the court thinks. But we raise the bar together. We insist and hold accountable the agency that is charged with providing the services to families, specifically in this conversation to Native American families. So not having a necessary service in the community is not a basis to find active efforts. So if the department, or if a court orders that a service is necessary for the reunification of a parent and child, then I don't have a contract in Asotin County is not the answer. It is, this is how we get that service connected to the parents. That's what active efforts would be. You know, I think the question about what evidence should DCYF use to prove active efforts in a termination trial, the tricky part of having to document everything you do when you are so busy doing it is that so much happens that doesn't get documented. But as I have said, we are courts of record, and without it in the record, it didn't happen. So social workers often find themselves in that place at trial where they're testifying about, they know they've done lots of things, and parent lawyers, where's that in your notes? Where is that in the record? And it's not there, because there's only so many hours in a day. So documenting what happens, whether it's in a court report from a social worker or a court report from an advocate, those are ways to document what active efforts have been done in a case. The recent case about active efforts from the Supreme Court is also a good read to understand why active efforts are important. Again, to prevent the breakup of a family prevents the destruction of a tribe. So tribes also benefit from the language of active efforts. And so it flows to the tribe as well to make sure that active efforts are being done. And so it's in the best interest of the child to have their tribe survive. So that's why, again, why active efforts are required in these cases, so that the tribe itself can survive. I'm getting to the end of the outline that I have for you. And I know I've been talking a lot, and I certainly don't mind. Keep going, because this is the day of the week that I enjoy the most. I wouldn't want to be a judicial officer if I couldn't do dependency cases. It is so difficult to come to work and talk about people's traumatic experiences and awful incidences of abuse and neglect. And that is balanced by and healed by being a part of the transformation of people's lives and the reunification of children with their families. And each family teaches me something that benefits the next family. And when I say, maybe I should just call that the case, each case teaches me something that benefits the next case. And so that includes how the child advocate shows up, how the social worker shows up, how the parent attorneys show up. In 25 years, I've been able to watch a system where foster parents and parents don't speak to each other, are afraid of each other, aren't allowed to even know who each other even is, to foster parents and parents coming to a court hearing embracing because of how much gratitude the parents had for the way that foster parent treated their child and helped keep that child safe and helped in the healing process so that the parent could be ready to have their child back. And these are the kind of transformations that this system very slowly is having, but they're coming. We're getting parent for parent programs in every community where people with lived experiences, which we're learning in all sorts of disciplines, are incredibly powerful to build that trust and have parents come engaged into a case because they have somebody next to them that they believe in, that they believe will tell them the truth, that they have heard there's hope and that things can get better. And no matter what I would say, because I don't have that lived experience, I can't be that powerful voice. So we're creating places of power and engagement in ways that this system has needed for a long, long time. In COVID, I have got to not only meet, but see so much more tribal engagement because people can appear remotely. And they are across the country or even just a few states away, but appearing in a court hearing by phone where you can't see anybody and you likely can't hear everybody is difficult and a lot of times ineffective. I have an incredible increase in tribal participation in court hearings. I had a lot of tribal participation in the case planning itself, but I have a lot more participation in court now because tribes can appear remotely. So we have COVID to thank for that because court systems were not open to the idea of anything other than personal appearances until we were forced to try it. And each community is going to come out of the pandemic differently, perhaps, but there's some of us working behind the scenes to make sure that remote appearance is still going to be authorized or required if someone can't participate in person. Okay, what questions do you have? What are you just dying to know about, and something that you think might help in your experience as an advocate for kids in courtrooms? Why do we do something a certain way? Or what is a court commissioner? I get asked a lot.
I'm going to ask, Your Honor, what you require out of a QEW, a qualified expert witness, if they come to court, and what kind of reports, declarations from them?
Yeah, so the qualified expert witness is a piece of the Indian Child Welfare Act that is required when a child is out of home, being placed out of home. And that expert has to have an opinion about whether the continued custody by the parents creates serious physical or emotional harm to the child. And so most of the QEWs that I receive say, yes, that's true. The continued custody of the parent makes it so this child is at serious risk of emotional or physical harm. Otherwise, the state would probably agree to send the child home if they couldn't get that requisite expert witness. But more often than not, I have parent attorneys who are arguing the weight to give that opinion because likely due to overwhelm and lack of resources, that expert witness has not ever spoken to the parent, has never spoken to the child, and their opinion is based on a review of records or a conversation with the social worker. So that makes it tricky to put so much weight on that expert opinion because the other side of the story hasn't often been considered. It's a piece, and the court really wants to know more about the child rearing practices of the tribe, because that is a piece that often is misunderstood by all of us in the room, especially what I was talking about of other family members doing education or other family members doing the child rearing practices. So those are important pieces for me, for the qualified expert witness. I give more weight to a QEW who has tried to reach out to parents and ask them about the things that the QEW is curious about on safety. And I hope the QEW talks to, if they can, if there's one appointed by then. Sometimes there isn't by the fact finding in some counties. the child advocate. I think it would be very difficult to be a qualified expert witness. So when the Washington Indian Child Welfare Act was being passed and being discussed in our legislature, some tribal members came to the table with the position, I will never testify against one of my tribal members. So it's going to be difficult for my tribe to be able to provide that qualified expert witness. And in the law, the first line of expert witness that courts are supposed to consider is a member of the parent or child's tribe. And there are some tribes that struggle with that piece. It's been a part of the Indian Child Welfare Act since 1978, so it wasn't new to the Washington Indian Child Welfare Act, which mirrors the federal law pretty closely, but that was part of the conversation. So it might be difficult sometimes to find that QEW. Now that more cases fit the definition of reason to know that the Indian Child Welfare Act would apply, we need more qualified expert witnesses. So I know the department is working on that, trying to get some agreements with different tribes to be that person. Some of these case files, as you know, are inches and inches thick. So to get educated about the facts of a case and be able to form an expert opinion in 72 hours or in 75 days could be very tricky. So I, of course, would expect a parent lawyer to make those objections. And at the same time, that doesn't mean the QEW is not qualified or shouldn't have made the opinion that they made. It's a weight argument at that point. How much weight should the court give to that piece of the testimony? David, looks like you have your hand up.
Yes, I'm going to ask you about the situation when you have like an adolescent child who, for pretty good reasons, absolutely refuses to have visitation with one of the parents.
Yeah.
And the other parent says, what do you want me to do? I can't drag him out into the car and get him to the visit. How do you deal with that?
Yeah, were you in my family law docket this morning?
I do family law GAL work a lot, so I understand what you're talking about.
And if you have teenagers, you know that if they are adamant about doing something, power struggles are typically not the most effective ways. So I think I started talking about kids needing resolution with their parents. It's psychologically absolutely important for children to get resolution. So in my family law cases or in a dependency case where I have a youth who, and I would agree with David, has good reason to not want to spend a lot of time with that parent, I require them to work on the resolution. So that usually has to involve a professional for them, so they can start working on the skills around being able to have that family counseling in a way that's geared toward resolution, not necessarily toward reunification.
And what do you do when you have a clinical psychologist who testifies that it would be detrimental to the mental health of the child and possibly cause post-traumatic stress disorder to push this too far?
I would listen to that recommendation.
Okay.
I would still require the youth to stay in that counseling for resolution. Closure is often very healing for people, and that youth can get there hopefully eventually, but sometimes it's not in their childhood.
Thank you.
It's certainly a very fact-specific kind or circumstance-specific question, because the parent might need to do some work too. We've all probably seen those cases where a child said this happened and a parent says, no, it didn't. How do we get past that? And that no, it didn't often comes from a mental health episode or inebriation from substance use. So they truly don't remember what they might have did or done or said. Or there just is never going to be a way to investigate whether something occurred or not. Some people can convince themselves that what happened did not happen. And that's an incredibly difficult fix. It's not an agree to disagree. It's, I am not going to agree to disagree that I wasn't abused by you. We just might not be able to ever have a relationship because you don't believe you abused me and I believe you did.
There's more questions, Your Honor.
The weight of WICWA recommendations. I would say probably a similar answer. What I just, if those of you who can see the chats, is what is the weight of LICWAC recommendations? So LICWAC is the local Indian Child Welfare Act committee that if the individual tribe, or we don't know what tribe is involved in the case or should be involved, can staff the case and give recommendations to the social worker. The department has a lot of policies about what to do with LICWAC recommendations and the requirement that they follow them. Absent a supervisor approval, it has to go up the chain before a social worker can disagree with the LICWAC recommendation. So you'll often see the LICWAC recommendation being the department recommendation, not really having a lot of difference between the two. That's what you will often see. If there is a difference, that would make me very curious as a child advocate. Why would there be a difference in what the local Indian Child Welfare Act committee is recommending versus what the social worker is recommending? Get to those whys. Is it a department policy, which if you understand tort law in the state of Washington, a lot of policies in the DCYF are based on tort liability. Can I get sued and will I have to pay if I do this wrong? And that is not a wrong way to do policy, but it's not always the best way to get to a child's best interest. So that might usually be the answer. So those kind of questions would be important to ask. What does it mean when a file statement from the parent's tribe states they are reserving jurisdiction at this time? I'm not exactly sure. So tribes under the Indian Child Welfare Act and the Washington State Indian Child Welfare Act have the right to intervene into a dependency case and become a party, somebody that gets notice of all of the hearings, somebody that gets to participate, somebody that gets to get the discovery, somebody that gets to put their own motions in if they want to. But they don't have the right to take the case into their tribal court system. So that's jurisdiction. So when the case is filed here in the state of Washington and there is not already a tribal court matter, because if there was, then the tribal court does get to take it and the state must dismiss it. But if there's no tribal court case and this case starts in the state system, tribes can ask to take jurisdiction, but parents can object. And if they do, the case cannot be transferred to the tribal court. So they might reserve that ask. That's how I'm going to interpret the question here. So tribes are thinking about, maybe we should, maybe we shouldn't. In my work as an AG, I would often see tribes wait till the permanency planning phase to decide if they have the resources to take the case into their tribal court system. If they were a tribe that is opposed to termination of parental rights, and that was the direction of the state case, you may ask at that point to transfer jurisdiction. And again, unless one of the parents objects, the court would have to find good cause not to transfer. So it's shall be transferred unless, and it's either good cause from the court or an objection from one of the parents. I don't think the youth or child or even the department can object. I haven't looked at this in a long time because I haven't had a contested motion on jurisdiction in years. But I think it's specific to the parent. Someone correct me if you know.
So Michelle, can I ask another question off of that?
Mm-hmm.
So with transfer over to the tribe, that means that everything would transfer over to them, or did the social worker stay on, or how does that work?
Yeah, so the social workers that work for DCYF wouldn't most likely be allowed to practice in the tribal court. So it would be the case would be transferred to the tribal court, and then that system takes over. Some tribes do have child advocate programs, and if it's a volunteer program, if you were the state advocate, you could ask to be a volunteer in the tribal court system. So it's not unheard of, that has occurred, but not all tribal court systems have attorneys for parents. It's not the law of the tribe that parents have lawyers. So those lawyers couldn't just go and practice. You'd have to have a license to practice in a tribal court system as a lawyer. Just because you're licensed in the state of Washington doesn't mean you can practice in tribal court in Colville, for example. So yes, the case would be transferred kind of like it would be, it would be dismissed in the state court. So that's how it would look to the parties of the state court case. It would be dismissed.
We really had a great presentation by two attorneys here in the state of Washington on those specific, intervention or, jurisdiction. So thank you for that.
Yeah. And so when a tribe has intervened, if you're the child advocate and you're asking for relief, you're filing that motion, make sure you're giving notice to the tribe, because that lack of notice will require a continuance of your motion. It might be urgent. So I don't want to run out of time to be able to reiterate gratitude, because it's so much appreciate your willingness to advocate for the children of our state. We all benefit as citizens of Washington when our children do well, when they grow up healthy, when they stay connected. They are not the citizens that make our lives more difficult. So to advocate for them and to advocate for their healing, their well-being, not just their temporary happy childhood, is such a lofty goal. And I'm so appreciative of people being willing to use their time, money, energy, probably in their own emotional strife sometimes, in willing to be that advocate for the children of our state. Thank you very, very much.
Commissioner Ressa, thank you. Thank you for your heart. It was mentioned to me directly in a chat that you have a gentle soul, and I feel that. And I'm just grateful that you were able to present in such a manner that was gentle, was informative, and I'm really grateful that I'm going to make sure the committee says Commissioner Ressa has to come back again at the next institutes, because you were very informative, and I can't thank you enough. And I raise my hands in honor of you for what you've done all these years. So thank you. Thank you.
My privilege and pleasure. It is so easy to build armor when things are difficult to hear and process. But the more we build armor, the less we're able to engage in a graceful and compassionate way with ourselves and with others. So start here. And I only say this because of the amount of practice I have to do on this particular issue. I don't find myself expert at it yet. I would work on it every day.
Perfect. Thank you. And so tomorrow we have NAIR and LICWAC presentations, and please fill out the evaluation form. And I know they're all going to be great. I know that.
Be honest, because I told Ryan before, I'm tired of having growth opportunities. I feel like I've had a lot of them lately. They still are important, and I want to always do better if I can.
Yes. Understand, because that's what we do. Learning opportunities in every little things that happen through the day. Yes. I love that attitude. Thank you, Commissioner. It's beautiful. All right, y'all. As I say, in Kuspu'us, we are one heart, one heart. So thank you. I hope to see you soon.